Okay, we're rolling. Well, mate, nice to have you back.
Yes.
Very much. It's been pretty quiet.
Yeah, nothing's been happening at all.
No, not much. No, I think everyone thought the world was going to erupt, but it's been pretty chill. No newspaper articles. Bank's pretty quiet.
Yeah.
Yeah, nothing.
We joke, of course.
Exactly. So, we're here. It is the 6th of December. And it feels literally like yesterday that we recorded that last podcast, but it is not stopped. Do you want to just sort of give us an overview? You've obviously seen a lot more than we've seen. Do you want to just give us an overview as what actually happened since the Johnson judgment was handed down?
Yeah, primarily the defendants in all three cases have filed and served a permission to appeal application to the Supreme Court. That was done at the end of November, and yesterday myself on behalf of Mr. Johnson and consumer rights solicitors on behalf of Mr. Wrench and Ms. Hobcroft filed a notice of objection and reasons why permission to appeal should be refused. Behind all of that has been quite a significant impact caused by the decision, mainly from the banking and motor finance sector. It's really caused shockwaves in the industry, and they're essentially saying it's going to disrupt things. The bottom line is they don't want to hand back all the egregious profits they've made over the years, and they don't like the Court of Appeal decision, and they're trying to have it overturned in the Supreme Court. And there is a real sense of outrage on their behalf. This decision is wrong and needs looking at, which I obviously disagree with. I think the Court of Appeal got it spot on, and the decision should be respected. And like you said, what's the problem?
Yeah, exactly. I think that's what's shocked me the most is the Court of Appeal, and I'd be the first to admit I've not read a million Court of Appeal judgments, but to me it was so black and white as to what's gone wrong and what the remedy is. And from our position, I think we said on the last podcast, it answered every single question you could ever want to answer regarding unfair relationship, disinterested duty, the lot.
Yeah.
For the lenders to come out so aggressively on all fronts saying they don't understand what the problem was, they trusted the brokers to do this, the client had every opportunity to read the small print, etc. Surely this is just one big, the ship is sinking and we're going to just go down fighting type attitude.
Yeah, I think they're going down swinging. And they're trying to recreate history. Anyone who's bought a car knows you don't have time to read through all the paperwork. And when you look at the paperwork, it's not clear. It says we may receive a commission. And I think I said on the last podcast, I may have had a croissant this morning.
Yeah.
Or, you don't know unless someone tells you. And they know what they're doing. Let's cut through all the nonsense and the gaslighting. They know why they put it on page 7 of 8 within the terms and conditions. We know why it's in size 6 font. We know why it's tucked away, because if they had it on the front of the agreement, people would start questioning whether this was a sensible transaction, or whether they could get it cheaper elsewhere, or whether they should just simply get a loan, or maybe they don't need that car. Not everyone who goes for a car absolutely needs it. Some of them just fancy an upgrade or what have you. So let's cut to the truth of the matter and look at it. Why was it done in the first place? And we know what's going on. We know when they drafted. This is what makes me laugh, Sam, really, is there's been this last-minute instruction of all these eminent counsel and a team put together from Magic Circle firms. Why wasn't that done at the start when they were drafting the paperwork? Paperwork's been drafted by a lawyer, I would imagine.
Yeah.
Why didn't that lawyer or team of lawyers, when they were drafting the paperwork, saying we may receive a commission, this might put us in breach of our fiduciary duty or could lead to an unfair relationship? Consumer Credit Act unfair relationship provisions have been out since 2007. A lot of these agreements post-date that. They knew what they were doing, or they ought to have known. So all this after the event Like you said, you say, going down fighting. They could have dealt with this at the outset.
Yeah, it is mad when you really step back of like what's actually happened here. You think when you actually look as to how this has been allowed to happen. I know just from sort of the compliance that we both have to go through, just to have a law firm, you have to be so careful of what you say.
Yeah.
And people will jump down your throat even if you get your privacy policy wrong on your website.
And rightly so.
Exactly. And to think these are lending, I think 31 million car finance agreements on that, according to the FCA. How was this ever allowed from the multiple layers of compliance and sign off and FCA regulation and so on? When you actually think of how this has been allowed to happen, it is just it's almost been allowed to happen, it feels like.
Spot on. I think it's poor regulation. One of the thrust of the grounds of appeal, and indeed it's featured in a number of articles by certain journalists who've come out to bat on behalf of the banks, is, well, our rules didn't say we should do this. And it's an argument that was trotted out in relation to PPI. No one told us that we need to disclose commissions. Well, on the one hand, the rules perhaps ought to have stated that, and if they didn't, that's due to poor regulation. But in any event, you should have known. The rules can't define and prohibit absolutely everything. So there has to be an element of, well, you ought to just maybe on the grounds of fairness, not hide commissions away. It's a pretty obvious point. This isn't something that's groundbreaking. If you were to speak to any man or woman in the street and explain what's going on, they would cotton on to the fact that doesn't seem right, and that's all it is. It's about transparency. So the reason we're here today is twofold, and I think it does boil down to the regulation not being good enough, and banks chancing their arm, thinking they can get away with it. And I don't know, maybe thinking, well, if we are caught out in the future, we'll have made that much money from selling these products. If we do take a hit for having to pay out claims, it's collateral damage.
Yeah.
But obviously what's rocked them backwards is the emphatic nature of the Court of Appeal decision. Like you say, it could not have been made any clearer. If you go to the end of the judgment, there is a question and answer section. In my view, and in my experience, that's unprecedented for the Court of Appeal to know that the decision will be looked at and still go further and say, look, if you want us to break it down for the county court and the judge who's hearing the case on that day, here it is. Here's a kind of a tick box guide if you need it. So it's unfortunate from the consumer's point of view that the banks have taken the inevitable step of pressing matters to the Supreme Court, because it does prolong somewhat the uncertainty surrounding it, because obviously the FCA and the banks are going to say until the Supreme Court look at it and give a decision, firstly on whether permission should be granted, or secondly, if permission's granted, what actually happens at the hearing, then the law's not settled. And in some respects they are correct, but in others the Court of Appeal judgment should be followed and it does bind the lower court and is the law today.
Yeah, no, I think you nailed it there, mate. And I think, did you see when the FLA director was taken into the House of Lords?
Yeah.
And he was absolutely grilled.
Yeah.
Did you see what that Lord Gravener that
Casey,
actually said?
Yeah.
When he just said, there's nothing shocking about the Court of Appeal's verdict. Basically.
Yeah. Well,
I think his actual wording somewhere.
I think you've got it.
To my mind, there is nothing particularly surprising about the Court of Appeal's decision, but you obviously think otherwise. Obviously, that was what Lord Grabner said to the Director of Finance and Leasing Association. I think that's pretty... that's what everyone is thinking when they read the appeal, but the press and particular people like Martin Lewis coming out saying it's shocking and it's unexpected and it was a landmark case and so on, all these weird and wonderful words that have been used to describe it as a shock.
Yeah.
It's anything but a shock. I mean, it goes one step further. I think he says, The Court of Appeal has decided that the commission payable to the broker was secret. It was not sufficiently disclosed. There is nothing unusual about that as a matter of legal analysis. And I'm just like, yeah. So what? Why the narrative?
Well, they want to spin a narrative that the banks are being treated unfairly. They want to shift the dial. But I think, particularly since COVID, I think the general public are a bit annoyed with being misled and being led up the garden path. And
on everything.
On everything, yeah. You know, big institutions doing what they like, but other people having to abide by the law. Like, you've broken the law. This is not unexpected. This notion is it followed a long line of authority that were all pointing towards this decision. It wasn't unexpected. Banks knew they shouldn't be hiding commissions.
Yeah.
The PPI scandal alone should have told the banks, shouldn't we be upfront about these commission payments? There's nothing wrong with the commission payments unless if you disclose it. If you don't, that's when the problems start. But they know if we don't disclose it, we can make more money. But are we breaking the law? Yeah, we are, but we want a lot of profit.
Well, this is the thing, you know, when I look at it and go, what actually happened, that the fact it was never disclosed, to me, would imply that they didn't want you to know.
Yeah.
You know, because it would hurt the deal. You would probably say no.
Yeah.
You'd want to negotiate. You know, if I was ever going to not disclose something, it would be to my own benefit.
Yeah.
And I just think when you actually look at it in the cold light of day like that, you go, well, they knew exactly what they were doing. It wasn't just a case of, oh, this is how the industry worked and the commissions were there and that's how it was. Yeah, oh, we didn't think to bring it to your attention. No, you purposely went out your way not to bring it to your attention.
That's it.
And I think it's mad. Just on the PPI stuff, what year was that? When did PPI really kick off?
Oh, I'd say, 2007.
2007.
Which is when I started looking at it.
Started looking.
Yeah.
And when did that run to?
It's still going on.
Still going on.
It kind of hit
2007
its kind of hit
going on.
its zenith. 2010 onwards, that's when it really got going.
So 2007, it really got going in 2000.
It started to gain traction, yeah.
2010. Yeah. So the FCA have come out and said everything from 2007 to 2021, obviously when DCA commissions was banned, 31 million finance agreements. Yeah. Of which 99% are affected, right?
It's like half the population.
But going back to 2007, so it's quite clear here. When PPI got shot across the bow and they really had to start looking at it, you would have thought from sort of a risk mitigation, they'd have gone, we're paying out billions. I think it was like 53 billion or something in PPI, and they paid it between, let's say 2010 and now.
Yeah, 14 years or so, yeah.
As part of like the overall risk analysis of whatever you go of your business, you go, shit.
Yeah.
I've got a lot of exposure on car finance commissions here.
Yeah.
And it's pretty much the same argument.
Yeah.
Maybe I should do something about that. But they didn't. They just paid out 53 billion.
Why?
No, knowing this was here.
Why? Because they were making money.
Yeah, making serious money. Yeah. And there's an obviously it's quite clear. What they paid out from car on PPI, they've absolutely cleaned up on car finance. So they knew this skeleton was in the closet and it was going to come out.
Oh, yeah.
I mean, you said something interesting to me just before we started recording about the investigation that's been going on by the FCA into this. You know, it started years ago, well before sort of lockdowns and all of that sort of stuff.
It was 2019 and then the report came out in January 2021 in relation to DCA agreements.
Yeah. And we're in the latter part of 2024 now.
Yeah.
They've extended the pause until May 2025 with the potential to go to December 2025.
Yeah.
There's the whole Supreme Court stuff going on that we'll get onto in a second.
Yeah.
You know, let's just make some bold statements. Compensation for clients, consumers. What, like, for any form of mass redress event to happen like PPI, what are we looking at?
If you take the view that 2025 is December 2025, in my view, is going to be the first occasion that they'll revisit DCA agreements subject to what's happening with the Supreme Court. Now, just touching on the Supreme Court, there is a request for it to be expedited, which I think is right.
Let's just cover that.
Yeah.
Expedited for everyone who obviously is listening. What's the typical process for the Supreme Court, and what does an expedited version of it mean?
Well, I've only had the one case in the Supreme Court, and that wasn't expedited. But I would imagine and this is just guesswork, if it were to be expedited, I would expect the Supreme Court to hear this by next summer, before
they would,
summer recess. Yeah,
before summer recess, it would be heard.
Yeah,
and that's been asked for an expedited one by what, yourself, the banks?
The banks have asked for it, and we, for the Court of Appeal process, it got expedited. So, fair's fair. We got it expedited but it was the Court of Appeal's decision, but no one objected. Based on the commotion, if I can call it that, caused within the banking industry, the FCA have said that they will write to the Supreme Court if permission is granted and add their support to it being expedited. I think it is in everyone's interest that we get to the bottom of it. Let's get to the end of the road, pun intended, with all this, and put it to bed once and for all. And then consumers can know, and everyone can get on with getting money back. Their money back.
But from an expedited version of what me and you would say is not. Like if I was to send something in Royal Mail, for example, expedited, I'd expect it to be there to like tomorrow.
Yeah, sorry, just to answer your point. So if and we're having to use guesswork, if the Supreme Court hear this in the summer, then I think you would expect a decision towards the end of next year.
Right. So there's a good 12 months to go.
Exactly.
For any form of, okay, this is what a redress scheme will look like.
Well, hang on. So the decision would be handed down in, say, end of 2025. Then the FCA have to digest the impact of that decision, come up with some rules, and then implement those rules. Now, if you look at the PPI example, Plevin was handed down in November 2014.
Yeah.
They didn't produce the rules from Plevin until March 2017. That's 2.5 years. Yeah. So let's be kind to the FCA.
That is crazy.
Yeah. So let's be kind to the FCA and say that they also proceed with expedition, seeing as they're a fan of it, and they produce their rules by the end of 2026. Then lenders will have a period of time there'll be a consultation on the rules. They won't just
implement them.
No, there's a consultation paper. There was one for what became known as PS 17.3, but basically the Plevin complaint rules. There was a consultation paper in 2016. If the rules come out at the end of 2026, you're going to have lenders time to respond. I do not think on that analysis, which is guesswork, that you would see rules that allow for mass redress for the consumer till the middle of 2027.
2027?
Possibly early 2028, which would be about 9 years after the FCA started looking into it. So from the period of when they started looking into it to when I think there will be an established route for redress for consumers, I think you're talking about 8 years.
And that's for a non-litigious sort of FOS redress scheme.
Yeah.
So we're sat here December 2024 for recording this now.
Yeah.
You think it'll be December 2025 before we hear anything as to which way the Supreme Court's going to lead?
If they give permission.
If they give permission to appeal.
Yeah.
And then there will have to be a full consultation period with the FCA, which will go out to the lenders to whether they agree with the rules or not.
And interested parties, so claimant representatives will be able to.
Yeah, so that'll probably be like
feedback.
the 7,000 consultation the FCA has done on motor finance so far. Yeah. Okay, cool.
Probably have a consultation about the consultation.
Yeah, exactly. I was going to say, maybe we need to have a conversation about the conversation to have the conversation. But so you're saying that we could be 2, if not 3 years away from any form of mass redress event for car finance claims.
Yeah.
So,
just let me add. Yeah. The thing is with PPI, it was quite straightforward how the redress scheme worked. They said it was almost a stepwise process. Did you receive a commission? Yes. Did you disclose it? No. Was it over 50%? Yes. Pay the amount over 50% with 8% interest. That was it.
Done.
Now, car finance claims, this is my gripe with Martin Lewis. It's not as straightforward as that. You've got rescission, counter restitution, unjust enrichment, unfair relationship provisions, equitable compensation. These are all remedies that only a lawyer in that field would understand. And Martin Lewis is suggesting Joe Bloggs can do it on the back of a fag packet and send it in and have a good chance, because, as I said, the banks will instruct external solicitors to field all their complaints, or they'll have a legal team within their department. So, it took them 2.5 years to come up with the PPI rules for plevin, as it was known. And that was easy. I've just gone through the 4-stage process. It was, it was very formulaic. It was almost guillotine-esque. Just chop the amount over 50%, add that percent interest, bang, move on to the next one. The car finance ones are complex.
Yeah.
Like, they're 10 times more complex than that PPI. So it might take 3 years, 4 years for the FCA to come up with adequate rules that would follow either the Court of Appeal decision, if it stands, or if the Supreme Court give permission and overturn parts of the Court of Appeal, or if they overturn it in full, then we can all, it's the end of the matter. But if they uphold or gives a different interpretation of the rules, and I say that when I say rules here, I mean legal principles, it's going to take the FCA a bit of time. And the bottom line is the consumer remains out of pocket, financially disadvantaged for something that's obviously a scandal, obviously isn't right and is smelly. But the banks sit on this money for 8-9 years.
Yeah, and I think that's what I've taken the most issue with since the Johnson judgment's come out. There's been a lot of talking heads, puppets of various different sort of bank side establishments, Martin Lewis being one of them, and I'll scapegoat him because I think he is the worst. But the oversimplification from the likes of them and the type of press articles that side with the banks, it is absolutely to the consumer detriment. I mean, like you said, saying that you can do these claims on your own. I mean, in theory, you can fix your own car, you can fix your own boiler, you can do anything on your own. Whether
fly your own plane.
Yeah, you can fly your own plane. In theory, yeah. Whether you're going to come out the back of it with the desired result, which is, from our perspective as like law firm owners, that you want to get the maximum redress for the client. And I think this is going into, and I think I've touched on this before, but we're starting to see things off the back of the judgment with Santander, for example, where they wrote to us in 2023 saying there was 100 quid worth of commission, 450 quid worth of commission. 2024 comes around. I mean, we had a letter off them in August. Oh, by the way, we found another £2,500 when we previously told you it was 400 quid. And I think this is the issue at the moment, that, with the FOS, with the FCA, with all of these people sat around waiting for redress, telling you to do it at the minute, you haven't got a clue what you're talking about.
Some of the articles I read were outrageous. They were outrageous. And the narrative and the spin they put on it. I think one article was "Don't bother claiming." It was something like that.
Well, I read,
which was insane. It's like, does that journalist want to set up a direct debit to lenders and pay them money willingly? And they've called it a frenzy. They've called it, one of them said, the obscure firms doing this. Well, I've won in the Court of Appeal 5 times. Maybe you should have looked me up, because I'm not obscure.
Yeah.
I've acted for a number of consumers in this field and been successful in the Court of Appeal. And some of the other firms are well established. It's disgusting. It really is. It's inaccurate at best, and it's, well, as I say, disgusting at worst.
It's like we discussed last night at dinner. There's a massive disconnection from all of these people. I mean, if you look at what the FCA said, 99% of the 31 million agreements are affected by some form of commission to the broker.
They've got commissions on them,
But the people who are obviously representing the banks, the people writing these spin articles saying you don't need to claim and stuff like that.
Don't claim.
They've been missold. If you've ever had a car on finance pre-2021, you have literally been shafted.
Yeah.
And this is what I don't understand. And even if they haven't had a car on finance, the friends will have, the significant other will have, someone within their immediate family will have been ripped off by this.
Exactly.
And that's the thing with PPI. I can understand it. It was like, it didn't really affect me. I never claimed on a policy. I paid on it. Whatever. There was various difference.
Discrete product.
But this is like, no. I know from
it's my car.
It was my car, and then I trusted you, and you've shafted me again and again and again. To the tune of not a couple of hundred quid like everyone's saying, thousands and thousands of pounds.
Yeah.
If not, in a lot of the cases we've seen, a very large portion of the annual wage that some of the clients that we've got, it's a significant amount of money. And I think what I wanted to ask you was that, do you think this narrative and kickback is because this grows arms and legs into a lot of other industries, and this is why we're seeing the so aggressive pieces and the talking heads come out so much, because it's not just about car finance, it's about a lot of other products.
I think you're spot on. I mean, let's just strip it back. All the Court of Appeal did was apply long established legal principles in a car finance context. That was it. And as soon as that decision was handed down, I think Close Brothers altered how they sold car finance. They just started disclosing the commissions. Well, that was easy, wasn't it?
Yeah, 5 days. That
literally
was 5 days.
Yeah, so it was really easy to do the right thing.
And it was very easy to understand. I went on their actual profile that they sent out to brokers, and it was a 1 page. I think there was about maybe 20 lines on there, and he was like, here's 4 things you need to do.
Yeah.
If you don't want to do them, we can't work with you anymore.
Yeah.
And I thought, 5 days from the Johnson judgment, and they did it.
So there's that. So they can correct the position.
Yeah, very quickly.
Very quickly.
And
the gripe is they don't want to hand back egregious profits that they've made by acting illegally.
Do you think they can?
Sorry?
Do you think they can hand it back? Do you think they've got the cash?
I don't care. They've got to make provisions for it. They've got to cut the cloth accordingly. But again, it's like, don't bother claiming. What kind of
advice is
that? Yeah.
You've been missold.
Yeah.
You probably are owed a couple of grand.
Yeah.
But just don't bother.
Yeah. It's like finding out someone sold you a TV years ago and the TV's stolen.
Yeah.
And you're like, well, I'm not happy now. Come on, you enjoyed the programmes on it. You watched Only Fools and Horses, and I know I did, but it was stolen. You misled me.
Yeah. No, you enjoyed watching that TV, Kevin. So
it was stolen. I'm not happy with you giving. I bought a stolen telly off you. Probably not the best example. Or the other one is
it's good.
Maybe you're in a relationship, and you find out at the start they cheated on you, and they're like, "Come on, we've had a happy relationship. Give you cuddles at night," and you're like, but you cheated on me at the start. I'm now not happy. I've learned something that happened at the start that's tainted our relationship.
Yeah, I would have never carried on.
Yeah.
I would have never entered the agreement, entered the relationship.
Exactly.
Yeah.
And, all these people's, wealthy journalists who are writing these articles, like you say, what if it was your mum? Would you be saying, don't bother, mum. Don't bother claiming, or you had a friend who wasn't as well off as you and they needed help?
Yeah.
I think they'd want Sentinel or HD law instructing them to get them the money back. This is people's money that shouldn't be taken. This is the other thing I have a gripe with, and it takes back to my English A-level days, and it was like the effective language, and I'm really fascinated by how these articles spin it. Cost the banks. No, the banks are handing back money they shouldn't have taken.
Yeah.
They're handing back money they've obtained through acting unfairly. They may see it as a cost. I don't want to give the consumer the money back that they shouldn't have paid.
Well, where does the bank's money come from?
The consumer.
Exactly.
Just give them it back.
Yeah. Well, the bank's money literally comes from leveraging all of the money in your current account.
Yeah.
So your wages every single month go into your current account. The banks take it, do whatever they can with it, lend it out. That's how they make money.
Yeah.
So you've taken a loan from banks' money that's collectively the Great British Public's.
Yeah.
And they've just shafted you on it. And they paid a load of commission out as well.
Yeah, they go cost and this, and as you say, I don't really care about the bank's historic liabilities now. They knew what they would. As far as I'm concerned, they knew when they were tucking it away that it wasn't right.
Yeah,
because they'll have engaged, or they ought to have engaged, lawyers to draft that agreement.
They will have.
Yeah, and the law was clear. Fiduciary duty laws, a long-established form of common law, and they've taken a deliberate step. Like you say, what did you think was going to happen? Have a look at what was happening with PPI.
Yeah. Did you not look?
Not disclose commissions is bad. That's in a sentence. I could give them advice in one sentence, or disclose your commissions. That's it.
Yeah.
And they didn't, and they wanted to get away with it. And the other shoe was dropped, and now they're on arms because it's like, we've got to hand back all this money we've made. There's going to be uncertainty in the market. No, there won't.
No.
You've just changed your processes. Market forces will level out, and people will get a better deal, on the car finance.
Well, I mean, the car finance stopped writing business, or the car finance industry stopped writing business for about a week, I think, was it?
Yeah.
And then they changed the policies and they got back to work. So it's not changed anything.
Yeah. Necessity is the mother of all invention. There'll be another way.
Yeah, exactly.
Yeah.
I was going to say, I'm quite sure the commissions are still somewhere.
Yeah.
Disclosed, probably, hopefully.
Fine. If they're disclosed, fine. It's sold as seen.
Mm-hmm. So the banks have objected, or they've...
sought permission to appeal, and we've objected to that.
Right, okay.
Which is a standard process that you do in the Supreme Court.
So let's just rewind. So Johnson was handed down 24th of October,
25th,
25th of October 2024. The banks then had how long to appeal?
28 days.
28 days. They filed that now.
They did it the day before. I think it was the 21st of November.
21st of November.
Yeah.
And then you've got to. What's the process for you off the back of them appealing?
We had 14 days to file and serve a notice of objection, a notice of acknowledgement, so to say we've got your permission to appeal application, and then we've put in reasons why permission to appeal should be refused. I mean, perhaps the most significant reason why permission should be refused is in the Court of Appeal decision, and the orders the Court of Appeal gave. They went to town saying, we are taking the unprecedented step, I paraphrase, but we're taking the unprecedented step of refusing permission, and they're giving reasons why permission was refused. Usually permission being refused can be a one-liner, but they, on all three cases, they were like, this will be an academic exercise. And if you want to appeal, if you want the Supreme Court to look at a breach of fiduciary duty, disinterested duty, tort, or bribery, the issues that the case stares up, it was choose a different case, different set of facts, different factual matrix, not a car finance one. That's not to say the Supreme Court might not give permission, but it just shows you the attitude of the Court of Appeal, who know their decisions regularly get appealed to the Supreme Court, nevertheless came in heavy and hard and said, this should not get permission for these reasons. So what we do now is we wait for the Supreme Court to either grant permission or not. If they don't grant permission, it's the end of the line. It's the Court of Appeal decision that stands, and that'd be brilliant news for the consumer.
What would happen, though, just playing devil's advocate, if the Supreme Court didn't grant permission? Would that leave an opportunity for the lenders and the banks to play games and go, well, we never really had our time and we don't agree with this?
No. As I said just then, it's the end of the line.
It's the end of the line.
That's it. That's the law. That everyone has to get on with it now, and it's basically stop crying. Start implementing this law. So the
reasons that they gave in regards for an appeal, they couldn't rehash it and go, well, we're actually appealing on different grounds now.
No, they'd have to do it all again.
Yeah. Do it all again in terms of...
But they'd have to appeal another decision, but...
They'd have to find something in the court.
But then you'd have a Court of Appeal decision which would bind the lower court, so it would be extremely difficult for a lower court to not follow Johnson. If they really want the Supreme Court to look at these issues, or fiduciary duty, disinterested duty, tort or bribery, maybe unfair relationships, but I doubt it. They're going to have to pick a different scenario of non-disclosure commission, not a car finance one.
Right, okay.
Do you see what I mean?
Yeah,
so it'd have to be, I don't know, something else, mortgage broker or a different, different type business energy, something like that, something different, where there's a different factual matrix, a different set of facts. What the Court of Appeal is saying is, car finance, we've done it.
Clear as crystal.
Yeah, this shouldn't do this then. But if they don't get permission, then that's it, end of the line. And it's brilliant news to the consumer because it means the courts have clarity and certainty. They can start implementing Johnson. The FCA, likewise, they can start coming up with the rules in line with Johnson. And the banks just have to find a way. All this, it's going to cost them money. As I said, I don't particularly agree with that phrase. But then they have to start making provisions to pay back money they've taken illegally to their customers, former customers, and cut their cloth accordingly. Or maybe have to lay staff off. Maybe have to get inventive or invest better. I don't know. I'm not advising the banks and wouldn't want to. But the world will keep turning. Just find a different way.
So the bar's pretty high to get permission to appeal to the Supreme Court. Anyway, isn't it? I believe it's something like 25%.
Yeah.
Of all applications
25% get
permission.
So it's you got a 1 in 4 chance.
Yeah.
I think what the banks have in their favour is the wider importance, and as you've seen, a lot of institutions are coming to bat.
Yeah.
For the behalf of the banks.
So let's just cover that then. So
Yeah.
from this, like the Court of Appeal have said, that any sort of review on this would be purely academic.
Yeah.
So talk us through sort of what is the Supreme Court going to be looking at here in terms of physically accepting or refusing permission? It's not just the interpretation of the law.
Yeah, well, yeah. They basically they would look at it afresh.
Mm-hmm.
So they're looking at basically the banks have set out in their grounds of appeal the reasons why they say the Court of Appeal decision is wrong,
mm-hmm.
and they've thrown the kitchen sink at it. They haven't accepted anything.
Yeah.
And then it's for the Supreme Court. Effectively, they'll look at it afresh and just give their own interpretation, and they'll see what the Court of Appeal have done, and they'll see whether they wish to agree with it or disagree. So, for example, in the other Supreme Court case I had of Potter, which concerned limitation in a PPI context, they agreed with the Court of Appeal's decision, but stripped it back a bit. So the thrust was the same.
Right.
So Section 32 was engaged where there was deliberate concealment of a fact relevant to a claim, which is the level of commission. But they just, without getting too technical, they just pulled it back a little bit.
In what way?
They said that Section 32(2) didn't apply the breach of duty. So it was just reliance on Section 32(1)(b).
So what did that mean to the consumer in the end?
In essence, nothing different. It was still...
The redress was the same, the compensation...
Well, it was more to do with when you could issue proceedings. So in instances where there had been deliberate concealment of a fact relevant, limitation would begin to run until you've discovered it.
Yeah.
Now, there is a third element to the act, the reasonable diligence point, which wasn't considered in Potter, so I needn't talk about it. But in essence, it was the same decision. It was just slightly watered down, but the thrust you still got over the line.
Yeah, okay.
As a consumer.
So from a consumer's perspective, they pulled it back, but it wasn't to the detriment of the client in a monetary sense.
No.
Okay.
That client, subject to reasonable diligence, could, in a PPI context, could still bring a claim if they could show that the commission had been concealed and they'd issue proceedings within 6 years of discovering that concealment. So it was a win. It was just not as emphatic as it was in the Court of Appeal. So I don't, obviously what the Supreme Court will do remains to be seen. Mm-hmm. But that's just to give you an example as to what's happened on it.
Yeah. But to summarise that, the Supreme Court, I mean, we've also got the judicial review on the Barclays Partner Finance case with the FOS.
Correct.
That's going to come out at some point. What that combined with the Supreme Court, do you think that's going to carry any weight on the Supreme Court decision, or
no?
Nothing.
No. It's a High Court decision. I don't know what's happened. I wonder whether that might get stayed.
Before they hand
put on hold, pending the Supreme Court. Everything seems to be on ice, if you like, pending this Supreme Court decision. Mm-hmm. Either on whether permission's granted, and then if it is, be on ice further because it will have the Supreme Court hearings and
what do you
judgment.
think? I'm going to put you on the spot. What do you think the Supreme Court's going to do?
I think they'll probably grant permission.
Yeah,
I think because of the wider importance and because there's been a lot of noise made from the other side and from the likes of the Finance Leasing Association, the FCA, in my view, have kind of added weight to the Supreme Court looking at it, and then the banks themselves. And there's not just the banks that are involved in this case. Black Horse have written to the Supreme Court. There was a letter you were mentioning to me, UK.
Yeah, UK Finance.
That's them.
That's them.
They've asked for it. So I don't know. I just obviously I hope they don't,
Mm-hmm.
and I think the Court of Appeal decision should be respected and left alone. They are entitled to seek permission to appeal, but I think because of the noise being made, that alone, forget the substance of the appeal. In my view, I think that alone will be enough for the Supreme Court to say, look, we've got to take a look at it.
Yeah, okay.
But I don't think that is determinative of just because somebody gets permission is really neither here nor there. To be honest, it's just that you're being heard out.
Yeah. Well, I think what's mental about it, and I think a lot of people don't actually appreciate this, is the sheer size of the market. I think, when you talk about the money involved here,
Yeah.
you would almost want that rubber seal to say there's nowhere to run it now, guys. I think that in the FCA's letter to the Supreme Court asking for it to be expedited, they put some numbers in that they quoted from the Finance and Leasing Association, and they said that in the 12 months leading up to September 2024, on new cars alone, there was 17.4 billion put out in lending on new cars alone, and then there was a further 21.3 billion put out on used cars. And it was something like 1.4 million used cars and 600,000 new cars were issued. And you just think 12 months, 2023 September to September 2024, that amount of money was put out. Over 2.1 million finance products put out.
Yeah.
And over 38 billion just in 1 year.
Yeah. And
then you look at you couple that with what the FCA sort of slid in. But I think a lot of people missed it a couple of weeks ago, and they said it was 99% of 31 million agreements had some sort of commission made to the broker. That's going to be a rising number, surely, because the commissions are still happening. They just banned DCA, fixed commissions. Black Horse are the worst for this. They call some of their commissions fixed, and they're not. They're fixed again as a fixed percentage of the total loan amount, so they get around it. But if you had a car on 50, 60 grand with Black Horse, I've seen Black Horse go fixed commission of 20% of the total loan. Well, that's 12 grand.
Yeah.
So this whole discretionary interest argument of like, oh yeah, it's only up till 2021, we banned it. It's not good enough.
No, and let's remember what's at the heart of these particular types of cases. They're secret. So you don't know. Like, I've seen it could be 31 billion. There's another article where in Consumer Rights think it could be 43 billion. It could be, you don't know. It could be double that. You literally cannot put an accurate figure on it because they hid them.
Yeah.
You've got to tell us, did you receive a commission?
We did.
Because it says may in the paperwork, and that could mean may or may not.
Exactly.
So I don't know. So everyone's guessing.
Well, we did off all of the wins that we've had in court, which is like well over 100 and odd now.
Yeah.
We took our average compensation that the client physically got and times that by the 31 million, obviously only accounted for 99% of the 31 million, but we put it at 82 billion if that was the average commission.
Yeah, it might well be.
And it's probably bigger because that's based off what the client took.
Yeah.
So it's massive. But in terms of just sort of going back to what the advice currently is in the market, and given your litigation experience and obviously everything you've discussed to say, this is where this market's going, and any form of mass redress event might be 2027.
Yeah.
What would your opinion be as to what consumers should do if they're affected?
What a consumer needs to be aware of is limitation periods that are running every day. The Consumer Credit Act limitation periods run from the end of the relationship. So it's called primary limitation, and that's 6 years from when your agreement ends. So if you've had an agreement that ended 5 years ago, you've got 1 more year before you can issue proceedings. Now there is, as I mentioned before, the secondary limitation period under Section 32, where you can say, well, you would argue this commission was deliberately concealed. I didn't know about it. Only found out in 2024. I've got another 6 years. But consumers really do need to be investigating whether they have a car on finance and then seeking legal advice and getting that legal protection. Not doing it themselves.
Not sending a letter of complaint.
Yeah, that's just preposterous. I don't think any consumer who acts for themselves is going to get a fair outcome, in my view.
What do you think about all of these letters of complaint that are going out at the minute through whether it's Martin Lewis or other non-litigious routes?
I've not really seen the letters, and I don't really want to be honest, because I kind of know what they'll say. But it's meat and drink for the banks, because what they'll do is they'll farm it out to external solicitors. There won't be a level playing field.
No.
And they'll probably, I'm guessing, able to probably reject it or bamboozle them with a 5-page letter quoting loads of case law. Or they'll probably say, we're not going to do anything until the Supreme Court give a decision. It's David and Goliath if you try and do it yourself. And you're playing into what the banks want.
Yeah.
The banks want easy fodder to bat away. They don't want to come up against a Sentinel or a HD Law or Consumer Rights or any of the other firms doing it, because that levels the playing field, and it's there's an equal arsenal, if you like, or weaponry between the two. And that's why we were able to take FirstRand Bank to the Court of Appeal and win, because we went at them hard. And Mr. Johnson couldn't have done that himself.
Yeah.
If he'd have listened to Martin Lewis, if Martin Lewis had given him that advice, I highly doubt he'd have got the outcome he's got. It would have been
a complaint.
it'd have been insane. A litigant in person in the Court of Appeal taking on the banks and their silks.
Yeah.
Do me a favour.
Yeah, exactly. Well, I think this is one of my gripes at the minute, is that anyone can issue a claim, anyone can send a letter of complaint.
Yeah.
It's what you do after it. Because these banks, they're not going to roll over.
Well, anyone can try and fix their own car.
Yeah.
Doesn't mean it'll make it down the M62.
Well, I think it's like you said, that the banks aren't just going to go, cheers for that 1-page A4
Oh, you've done
paper.
it yourself. Let's go easy on you. Yeah,
exactly.
Yeah.
But I think for anyone, whether it's a professional firm or not, or whether you're doing it yourself, you're sending a letter of complaint. You've got to be prepared for them to say no on the other side.
Yeah,
and
in my experience, 100% of the time, they say no. Then they file a defence saying no again. Then they instruct external solicitors, sometimes from the city, saying no, and then they'll try to strike you out, or they'll instruct barristers interlocutory or interim hearings, and then they'll push it all the way to trial. Doesn't matter that the claim's probably only worth maybe £2,000. They'll instruct somebody whose fee. Yeah, they don't care. But because guess what? They've got lots of money to burn, because they've made lots of profit because they were selling products illegally.
And then you've got to roll the dice on what judge you get.
Yeah.
Yeah.
And then you're going to roll the dice on the court listing. You could get blocklisted. So you could get to court and you could be listed for a day and then find that you're alongside 5 other hearings.
Yeah. But I think just going back to the whole letter of complaint process, this idea that you can send a letter of complaint and lenders are just going to eventually pay out.
No.
Absolute nonsense.
No.
Nonsense.
No.
I think...
Look how they reacted to the Court of Appeal judgment saying, you shouldn't have done this. It's illegal. Yeah. What have they done? They've gone to town and getting expensive barristers from eminent chambers. They've instructed Slaughter and May. They've had 3 partners on the appeal.
Yeah, I think I genuinely think
they've gone bananas with the muscle they've got from the finance. So the idea that a litigant in person doing like a letter of complaint, the bank's going to roll over and have the tummy tickles. Like look at what they do.
No, I totally agree with you, and I think the market on the claimant side has got to get real, because I think if you think that you're ever going to send a letter of complaint out, and the banks are going to go, yep, okay, here's your money, and we're going to give you the full amount, and they're not going to basically give you a final response letter saying we're not going to uphold this. You've got to know how to package it, send it to FOS. You've got to have the information on the client, not just a registration number and so on. And I personally think there's a very real chance if claimant firms don't collaborate more over the next 12 months, someone's going to mess it up.
We must. We it worked really well on the limitation case. There was a cohort of us and we all pulled together, and we need to do the same on this. Because we are the voice of the consumer. We've been called ambulance chasers and vultures.
Well, it would never have gone all the way to this where it is now.
That's just a disgraceful accusation. But also, if the banks don't missell, then I'm not doing this area of the law.
No, exactly. You wouldn't exist. You wouldn't
exactly. I'm a creation of your scandal.
Correct.
Another scandal.
Yeah.
It made me laugh. The likes of Black Horse and other I think Close Brothers may have mentioned it, that, you know, they've been working in consultation with the FCA.
Yeah.
I'm like, the only reason you're working in consultation with them is
Yeah.
because you caused a mess.
Correct.
And they've had to say to you, you've caused a mess. Can you tell us how you've caused this mess? And
Yeah.
oh no, we were asked to consult. Like,
No.
you caught your hands red-handed in this scandal, and the only reason you're getting listened to is because you were the cause of it, and they want to understand what's gone on here.
Yeah.
Yeah, the narrative, as we said before, is it can be quite anti-claimant.
Mm-hmm. Yeah.
I was thinking about this the other day. There's an Elvis Costello song. I don't think it's his, but it's like, what's so funny about peace, love, and understanding? I had it in my head, and I was like, what's so wrong with openness, transparency, and being nice to your customer? Like, why? What's the aversion to that? Why can't we just don't hide things? Don't try and rip people off. As I say, I think what happened with COVID and the way the world changed, and you know, it's shone a light on a lot of things, COVID. And I think the general public had just had enough of being taken for a ride. Like, stop taking the absolute piss.
Yeah, and I think that's it. I think that's across the board. I think this is, you know, I've said it in a couple of interviews now, is that this isn't just about car finance. You just constantly, like, again, shafted. You know, whether it's on the energy prices, whether it's on car finance, whether it's on PPI, whether it's on, you know, banking charges, or, you know, all sorts of stuff. The consumers just had the absolute piss taken out of them.
So we were out last night, right? Imagine if I said to you, I'm going to the bar, give me 10 euros or 10 quid. And you went, okay. And I bought you a drink, didn't give you any change. And you went, right. I said, that was three quid. I'm keeping 7.
Yeah.
Just because I went to the bar. But I never told you. But you, even though you'd be like, hang on, whoa, you can't be doing that. It's the same. It's that notion of you've hidden something from me.
Yeah.
If you'd have told me that, if you'd have said, I'm going to charge you £7 for going to the bar, you say, I'll go myself. Or actually, I don't want a drink or whatever. It's the like, you sneaky bugger. You know, you didn't tell me at the time. And that's the thrust of it. That's what it is at its most basic level, is just tell me what I'm paying for. Stop hiding stuff. Stop tucking things away.
Yeah.
The public are fed up with it, you know, and they've been taken for the ride. How many more scandals do we need? How many more scandals, national scandals, that the banks cause, do we need before there's a notion of, we shouldn't do this? Why don't we sell things in the right way? Why don't we, when we instruct these army of lawyers, get the drafting right, get the wording right in accordance with the law, stop tucking things away? That's where it started. Not now. They're bringing in all these barristers now to clean up the mess. The mess was caused the moment you knew, when you were drafting your paperwork, that doesn't look right. That looks a bit unfair.
Yeah, no, you're absolutely right, mate. Kevin, we'll leave it there, mate. But that was really, really interesting. And I think, I think it's going to be interesting.
Yeah, certainly
We'll
is.
see what happens.